The Queensland Magistrates Court do not swear an oath to the Queen. They have no authority to deal with matters for the Queen or on behalf of the Commonwealth. However, two Justices of the Peace, whom do swear allegiance to the Queen in accordance with the Justices Act, form a court of lawful jurisdiction to deal with Commonwealth charges and convene a Magistrates Court. The lawyer tried to having the court deal with myself, and the magistrate ignored the fact that he was not a judge and it requires two judges to charge someone as being a vexatious litigant. So I did a video explaining that. When we came back to court, then instead of myself being deemed, only wanted the action to be determined without the recordings as being vexatious based on the fraud that was tendered to the court, which was the fabricated evidence being tendered as an exhibit from the Federal Magistrates Court. So that the court could not make any determination whether I was vexatious or not, I withdrew the charges on the basis that Dr. Chalk paid for the bill and accepted that. His bill was over $5,000. He agreed to pay it as long as I didn't bring these matters either back to a civil or criminal court. However, by myself withdrawing was only a tactical move to ensure that the magistrate didn't try to suggest vexatious when the evidence was not tabled. I knew that it would be their move. I expected it. I have planned this from the beginning. They have tendered what I required as being the altered transcript as evidence. Now you know why I needed both cases running separately. I now, since withdrawing the case, would normally have no ability to be able to subpoena the recordings. This is where the second case comes into play. Using the second case, where the recordings are necessary to prove were altered as being on the charges on that case, I did require the recordings. I have now got tendered evidence on the court record. I have a subpoena for the recordings. The next problem is that the magistrate will be unwilling possibly to give the recordings to myself. So therefore, if I nominate a state police officer to withhold or to be given a copy, I can then listen to them at the police station with the transcript tabled as evidence. With two JPs and a police officer, I can confirm that the crimes do exist. Everything is played out, and I knew that I had to be particularly different in these proceedings so that lawyers didn't have the upper hand in understanding what my procedure was going to be. And they were expecting that the courts would be cleared and ensuring that this case would never see the light of day. I show what is my intent in this court proceeding is to gain what was ordered by a Justice of the Peace, which was for the surrendering of the recordings of all days within the family law proceedings. What all parties are trying desperately to imply is that I am breaking the Family Law Act of Section 121 for exposing parts of my family law case, when I'm actually not. I'm exposing crime. No law protects criminals from conducting crime, so therefore I have the right to expose this, and I endure these games played by magistrates and government bodies and lawyers to ensure that this is exposed to the Australian people. I will have, and previous videos have explained many of the crimes and how a psychiatrist is more concerned for reams of paper than actually reading, and why the lawyers run away from this case after exposing their crimes, and a magistrate is ignoring the fact that they have run away and not informed as to the reasons why they have run away. We have a Queensland legal aid lawyer who offered a property settlement, and I have conditionally accepted based on that the lawyer accept to answer 10 questions on the penalty of perjury and of what expired in these proceedings. It was also stated that should they ignore, it will be understood by everyone that they will under no circumstances speak the truth, even to close a property settlement of what transpired in that court.